to Dr. Olu Asekun podcast. Today is another beautiful Wednesday. Please invite your family, your friends, your colleagues at work, and join us as we continue with this podcast. Today, we are discussing permanent labor certification. The topic for today is permanent labor certification. Permanent labor certification is something that comes up in virtually every employment-based petition, of course, with the exception of EB5 and EB1, as well as EB4. So, but whenever we discuss the issue of employment-based immigrant petition, permanent labor certification always come up. So the question is, what is permanent labor certification? Permanent labor certification is a process or a system that is put in place by the US government to prevent employers hiring foreigners from having adverse effects on the working conditions of American citizens. In other words, they don't want employers to go out there and bring in cheap labor, which will in turn adversely affect the working condition of American citizens or anyone authorized to work in the US. So that is why they want to be sure that even if an employer is going to bring in a foreigner to come and work in the US, those employers must pay the same amount, at least the same amount of minimum payment obtainable from American citizens here in the US. In other words, if a lawyer, for example, is getting paid 100,000 per year in the US, an employer cannot bring in a lawyer and then pay that lawyer 80,000 or 50,000. Of course, every employer will go for what is cheap. So that means that employer will start going for foreigners, and then American lawyers will start losing their jobs. That is just an example of why labor certification is important. Now, labor certification process is a condition precedent to immigrant visa petition for categories that are affected. In other words, if your category, that is EB2, EB3, and EB2 and EB3, if your category involves labor certification, you must apply and obtain the labor certification first before you can kickstart the immigration process. So in other words, what that simply means is that if you are applying for green card based on employment in the category of EB2 or EB3, then the employer must first obtain permanent labor certification before they can even start the immigration process with USCIS. The only exception is EB2 national interest waiver. Of course, as the name suggests, the applicant in that case is asking the Department of Labor or even the Department of Homeland Security to waive the requirement of permanent labor certification. But in the absence of that, for every EB3 category, permanent labor certification is required before an employer can hire a foreigner. As I clearly stated, permanent labor certification does not affect EB1. It doesn't affect EB1. It does not affect EB2, those that are applying in the national interest waiver. It does not apply to EB4. EB4 are special immigrants. Permanent labor certification does not affect it. And of course, it does not affect EB5. EB5 are the investors, those who are bringing money to invest in the US. So permanent labor certification does not affect them. So generally, permanent labor certification only affects EB2 and EB3. And of course, EB3 is the skilled worker. That is where permanent labor certification really matters. However, even in under EB3, we still have a couple of exceptions. So we have exception in the case of nurses. We have exception in the case of physical therapy. Those are Schedule A occupation. And of course, we also have exception in is it readers, ship readers or something. Sheep herders? Is it sheep herders? Yeah. I don't even know what that means. I've never had to do a sheep herder. Yeah. I've never had to do that since I've been practicing. So, but the most common is Schedule A occupation, which is nursing and physical therapist. And of course, it does not affect religious occupation. All these come under EB4. So, if you have questions relating to permanent labor certification, start sending the question in. Start sending the question in. If you have questions relating to permanent labor certification. In the meantime, I have to keep explaining why labor certification, or what does labor certification mean, the impact of labor certification, what is the process of labor certification. Now, a lot of employment-based non-immigrant visas require a labor certification before an applicant can transition from non-immigrant to immigrant visa. For example, H1B. For those who are on H1B, thank you. For those who are on H1B, for you to transition from H1B to green card, your employer needs to go through a process of labor certification before they can even apply for immigrant visa for you. The only exception, as I stated before, maybe someone who is a physical therapist. I will not quote nursing as an exception here because generally nurses do not go on H1B. Nurses do not go on H1B because H1B is a specialty occupation that requires a minimum of 4-year college program. So, and because nursing, somebody can become a registered nurse by going through a 2-year college, by going through even though some people may also obtain a bachelor degree in nursing, but because the minimum qualification for becoming a nurse is a 2-year program, nursing is not eligible to file H1B. So nursing does not qualify for H1B. In the past, long time ago, they used to have a special class for nursing. It is called H1C. It used to be called H1C at the time, but that program has since ended. And of course, nurses do not go through H1B. But of course, that's a benefit because nurses can go directly for green card, unlike most other professions. Generally, skilled workers, they start from non-immigrant and then proceed to immigrant. But in the case of nursing, they can go directly to green card. For example, somebody can graduate from nursing school, pass the NCLEX, and then apply for immigrant visa right away because labor certification is not required. For most skilled workers, this is not possible because they will have to first go through the process of labor certification. And if they are physically present in the US, because they have to maintain legal status, they will probably have to have a form of non-immigrant status to keep themselves in legal status, such as H1B. H1B is usually valid for 3 years and it is renewable for another 3 years, making a total of 6 years. And in some cases, it could be extended beyond the 6 years if the applicant has an immigrant petition that has been pending for over a year, for at least 1 year, or if an application for labor certification has been pending on behalf of that applicant for at least 1 year. So in such situations, it could be extended beyond the 6 years. So, as I said, to transition from non-immigrant to immigrant generally requires the process of labor certification. There is no skilled worker that can transition from non-immigrant, or even if you don't want to transition, that can apply for immigrant visa without going through the process of labor certification, with the exception of nursing, physical therapists, sheep herders, and religious workers. Those are the only exceptions. For every other profession, they are required to go through that process called labor certification. Now, that takes me to the question. No, I think something is wrong. I don't know what. That takes me to the question, then what is the process of labor certification? Now, as I just want to see, have we started receiving questions? Okay, so let me keep going. I'll come back to the question. But if you have questions, keep sending them in so that once I start answering the questions, I'll just keep going. But for now, I just want to quickly give an overview of the process of labor certification. As I stated before, labor certification is a process that is handled by the employer, not the employee. So in other words, if you are the employee, you cannot process labor certification. Labor certification can only be processed by employers. They cannot be processed by employees. In some cases, the employee may want to know the process, maybe just for informational purpose or for record purpose, but the employee is generally not involved in the process of labor certification. It is the employer that has to go through this process. Secondly, because it is the employer that has to go through the process, there are specific steps that the employer must take before they can even apply for labor certification. Labor certification process requires an application. So an employer has to complete an application. That application is called Form ETA 9089. That is the application form. So an employer has to complete that form and submit it to the Department of Labor. However, before the employer can do that, the employer must have completed what is known as recruitment steps. What are these recruitment steps? One, the employer must have placed an advertisement in a major newspaper in the area of intended employment. In other words, it is not the area where the employer is located. It is more like the area where the proposed employee will be working. For example, if a company with a headquarters in California want to hire an employee who will be working in Dallas, Texas, the employer in such a situation will have to place the advertisement in a major newspaper in the Dallas-Fort Worth metroplex. So, because that is the area of intended employment. If the advertisement is placed at the employer's principal place of business in California, such an application for labor certification will be denied. Such an application will be denied because the advertisement has to be placed in the area of intended employment. It is the job location where the employee will be working. That is where the advertisement must be placed. Now, why should the advertisement be placed in the area of intended employment and not the employer's location? The reason is very simple. When it comes to labor certification, the employer must obtain what is called prevailing wage determination. In other words, the Department of Labor must confirm and provide a wage to the employer that, look, for this particular position, you cannot pay the employee less than X amount of money. Still using the example of a lawyer, let's say a law office intended to hire a lawyer in that Dallas metroplex. They will have to contact the Department of Labor by applying for what is called prevailing wage determination. Now, it is the Department of Labor that will now tell the law office that, look, For you to hire a lawyer in Dallas, you have to pay that lawyer $200,000 per year or $50,000 per year, as the case may be. So it is the Department of Labor that will make that determination that this is the minimum amount of money that you must pay the applicant. So that is why it is important that the advertisement is placed in the area of intended employment. One thing is certain: in the US, wages vary. The same exact position, the same exact qualification may attract different salary depending on the location of the employment. For example, we all know that getting a job in New York, Manhattan, for example, will probably attract a higher salary than a place like Tennessee. Maybe California, for example, may attract a higher salary than a place like Texas. So it depends on what is the living condition in the area of intended employment. Those are some of the things that are added to the wages and salaries of people, and that is why an employer must apply for prevailing wage in the area of intended employment before they can commence the process of labor certification. Now, going forward with the process, after obtaining the prevailing wage, the employer must now place an advertisement at least twice in a major newspaper in the area of intended employment. Having determined how much the prevailing wage is, the employer cannot offer any salary that is lower than the prevailing wage. If the prevailing wage is 100,000, if the employer in its advertisement offered 95,000, that application for labor certification will be denied, because it cannot be less than the prevailing wage. On the other hand, if the prevailing wage is 100,000 and the employer decided to offer 120,000, it will still be approved, because it is the minimum that cannot be less. It can be higher, it just cannot be lower. So it will still be approved. In addition, after placing the advertisement in at least 2 Sundays in a major newspaper in the area of intended employment, the employer must also place advertisement with the state workforce agency. State workforce agency, depending on the state where the employer is located or where the prevailing wage is located. Generally, the advertisement must be placed with the state workforce agency in the area of intended employment. Going back to my example, if the employer is in New York but the intended area of employment is going to be Dallas, the advertisement must be placed with the Texas Workforce Commission, because that will be the state workforce agency for Texas, for Dallas. So the employer cannot, even though the employer is located in New York, the employer cannot place the advertisement with New York Work Agency. It has to be Texas Workforce Commission. So the advertisement must be placed in the area of intended employment. Now, after doing that, the employer must still place advertisement in at least three online job search websites. Now, it doesn't have to be only online job search website. There must be 3 additional recruitment steps. But I always refer to the online job search website because that's about the easiest way. I mean, there are several online job search. I don't want to mention names because I don't want to give free publicity or undue advertisement. So I'm not going to mention names. But everybody living in the United States or even living anywhere who is planning to apply for employment-based green card must be able to know what is called online job search website. That is, websites where people go to look for employment. Different websites where people go to look for employment. At least 3 of them. The employer must place 3 additional recruitment steps. Now, after doing all of that, if there are still no American citizens interested or eligible or qualified in doing the job, the employer must still go further and place advertisement in the employer's website if they have one. They must place advertisement in the employer's website. In addition, they must place what is called notice of job offer. Before, all these steps must be taken before they can even file application for labor certification. So they must place advertisement in a major newspaper. They must place advertisement with the state workforce agency. They must place advertisement in at least 3 online job search websites. They must place advertisement in the employer's website. They must place notice of job offer in the employer's principal place of business. The notice of job offer must be there for at least minimum of 10 working days. 10 working days. Weekends are not included. It must be at least, the notice must be there for at least 10 working days. Now, one of the information that must be contained in the notice, the employer must indicate that this employer has an opening. Using the example of a lawyer, this employer has an opening for a lawyer. The employer intends to hire a foreigner. If anybody has an objection, they should contact the Department of Labor. Their address is ABCD. Their phone number is XYZ. So those information must be placed at the employer's principal place of business for at least 10 working days. Now, after doing all of this, if there are still no American citizens who are interested or who is eligible or qualified to do the job, then the employer must go further and submit an application for labor certification. Now, after submitting an application for labor certification, the Department of Labor will review the application and then take a decision. Now, they have 3 options in taking decision. They can review the application and summarily approve the application. Once they approve it, there is a sentence at the towards the end of the application for labor certification where the Department of Labor will state that we certify that there are truly no US citizens available or interested in doing this job. That simple sentence is what is known as certification. That is the certification we are talking about. That is the labor certification. So once that certification is given, then the employer can now start the immigration process by filing Form I-140, Immigrant Petition for Alien Worker. Now, the permanent labor certification is not indefinite. It is something that has a deadline. After the certification, an employer has up to 180 days to use that application. So if the labor certification is not used within 160 days, if the employer intends to hire a foreigner, the process will have to start all over again. So it is not a certification that is going to be kept forever. Once the certification is made, the employer has only 180 days, which is 6 months. Of course, if the employer genuinely needs an employee, a foreigner, after certification, 6 months is a lot of time. It is a lot of time. So they have up to 6 months to use it. But if they don't use it within the 6 months, they will have to start the process all over again. Now, the second thing that the Department of Labor can do after reviewing the application for labor certification, the Department of Labor can also summarily deny the application. They can deny the application. Generally, from my experience, the only reason that will make a Department of Labor deny summarily an application for labor certification is if there is any part of the application that is illegal, if there is any part of the application that is contrary to law, if there is any part of that application that is a violation of law, of course they are not even required to ask any question. They can go ahead and summarily deny an application. Let me give you an example of what constitutes an illegality when it comes to application for labor certification. If an employer places an advertisement and a part of that advertisement is illegal, then that will be a basis to summarily deny the application. An example, let's say my law office, for example, we want to hire a lawyer and we place an advert that says something like this: attorney wanted, applicant must have Texas license, applicant must have minimum of 1 year experience, applicant must be able to speak Spanish, or applicant must be able to speak French, or applicant must be African American, or applicant must be Caucasian. Those last 4 sentences, applicant must be able to speak Spanish, or applicant must be able to speak French, or applicant must be African American, or applicant must be Caucasian. Those are illegal content. Those are illegal provisions. Any of those ones will attract a summary denial. For example, it is not a requirement that an American must be able to speak Spanish before they can get a job. It is not a requirement that an American must be able to speak French before they can get a job. It is not a requirement that an American must be able to do any of these things before they can get a job. So this clearly shows that employer is not making that advertisement in good faith. Rather, the employer has a particular candidate in mind, and that is why they are placing that kind of condition in the advertisement. Of course, to say that the applicant must be a Caucasian or the applicant must be African American, those are illegal provisions. Of course, a private company may choose to hire whoever they want, but remember, when an employer is applying for a labor certification, that employer, for that purpose, has become a public interest, because the employer now is leaving out American citizens and is requesting an authorization from the American government to bring in a foreigner. So there is a public policy interest in this case. So where an employer is asking for a favor from the government in the public interest, the employer cannot include a violation of law. The employer cannot include a provision that is contrary to the same public interest that they are trying to protect, that the government is trying to protect. So that is why that kind of application will be summarily denied. Now, the third thing that the Department of Labor can do, remember, I've discussed the application being summarily approved. I've discussed the application being summarily denied. Now, the third thing that the Department of Labor can do with the application for labor certification, they can choose to audit the employer. Now, this is one of the major reasons why a lot of companies do not go through the process of labor certification. A lot of companies don't want to expose themselves to to governmental sanctions, because where the Department of Labor decide to audit the employer, if they determine that the employer was actually not making the advertisement in good faith, that employer could be sanctioned. That employer could be given financial fines. That employer could even be prevented or banned permanently from ever hiring a foreigner, or maybe for a specified period of time from ever hiring a foreigner. So all these things comes with auditing. Auditing means that, okay, when you place this advertisement, how many people apply? Can we see copies of their application? Can we see copies of their resume? Why do you believe they are not eligible? Did you even consider them? Did you invite them for interview? How did you communicate the interview with them? Did you talk to them over the phone? If yes, we want to see your phone record. Did you send an email to them? Did you communicate with them through email? If yes, we want to see the copy of the email. Did you send letters to them? We want to see proof of delivery. We want to know that this job offer was actually in good faith. It was not something that is sketchy, or something that was done when the employer already predetermined who the successful candidate will be. So they look at all these things. At the end of the day, if they realize that the employer actually follow through on each of the recruitment steps, they will still go ahead and approve it. On the other hand, if they discover that the employer was actually trying to play smart, or trying to cheat the system, or trying to ensure that a preferred candidate emerges as the candidate, that employer could be sanctioned. So this is the process of labor certification. Now, upon the approval of the application for labor certification, that is when the employer can now commence the immigrant immigration process. Armed with the labor certification, the employer can now file what is called Form I-140, Immigrant Petition for Alien Worker. And of course, depending on the category, if visa is available, the employer can concurrently file Form I-485 together with the I-140 application. Of course, where visa is not available, the employer will file only I-140 petition. Now, let me say this. Unlike every other immigrant process, unlike every other employment-based immigrant process, where application for labor certification is involved, the date that the application for labor certification is submitted to the Department of Labor, that will be the priority date, not the date that the I-140 was filed. The priority date will be the date that the application for permanent labor certification was submitted to the Department of Labor. So I believe that there are questions right now. Okay, yes. Let me start answering the question. Question received via text message. Is there an expiration to the labor certification once it's approved? Oh yes, I've already answered that. Once the application for labor certification is approved, it is valid for 180 days, which is 6 months. So after the application is approved, the employer has 180 days to use the approved labor certification. If it is not used within the 180 days, then the employer will need to start the process all over again. The next question: does the labor certification need to be filed by an attorney? Well, generally it has to be filed by an employer, but an attorney can represent an employer. Permanent labor certification process is very technical, and as I have explained, it could be denied for any reason. Any little violation could lead to denial. So it is advisable but not mandatory. It is advisable to use the services of a lawyer to process it, but it is not advisable. One of the benefits of using a lawyer, when I was explaining it, I mentioned that even an advert, a labor certification application could be denied where an advertisement is in violation of law. And this is one area where a lawyer may be able to review the advertisement before it is placed. Because once the advertisement is placed and then that advertisement is used to apply for labor certification, if that advertisement, if there is any portion of the advertisement that is a violation of law, it will eventually lead to the application for labor certification being denied. So it is better to engage a lawyer who can review every stage of this process and ensure that the employer is complying with the law at every single stage. But again, it is not mandatory, it is optional. The next question: once the labor certification is approved, can I work for a different employer and still get the petition approved? Well, it depends on how, on the stage. It depends on the stage where the labor certification and the I-140 application is. Generally, where a labor certification has been approved, an employer or an applicant has submitted application for immigrant petition for alien worker concurrently filed with application for adjustment of status. If that application has been pending for at least 180 days, then the beneficiary can change employer. The beneficiary can change employer and without losing the benefit of the approved labor certification. But of course, where the labor certification has not been approved or where the application has not been pending for up to 180 days, if the beneficiary change employment, the beneficiary may need to, the new employer may need to submit a new application for labor certification. The next question: why are these recruitment steps required? Well, I believe I've already answered that. They are required because it is the responsibility of the American government to protect American jobs. And one of the ways to protect American jobs is to ensure that employers are not bringing in cheap labor that will impact the working condition of American citizens. So every American is deserving of getting employment. So if the prevailing wage is a particular amount in the US, an employer may choose to go and bring in cheap labor, and then the Americans may start losing their jobs. So it is to ensure that the working conditions of American citizens are not affected. That is why the labor certification process is put in place. The next question: does an approved permanent labor certification give a foreign worker the right to work in the US? No. Permanent labor certification is not a right. It is a required process before an employer can commence the process of permanent labor certification. It is not an employment authorization. It is, as I said, it is not processed by USCIS. It is processed by the Department of Labor, and we all know that the Department of Labor does not issue employment authorization, so it cannot be used for employment purpose. The next question: everything you are mentioning sound very complicated, and these are many steps to take. Do people actually get this labor certification approved? Oh yes, oh yes. People do get the labor certification approved, but to be honest with you, it is not easy. It is not easy to get it approved because especially in this modern day, it is extremely difficult for any US employer to place advertisement and not get American citizens to be interested in applying. It is very, very difficult. In the past, yes, it used to be very easy, but in this day of internet, Wi-Fi, online thing is very, very difficult, because in the past, when an employer places an advertisement, especially in the area of intended employment, when people used to place advertisement in newspapers, number one, these jobs will be viewed by limited number of people. A lot of people don't read newspapers at the time. A lot of people may even pick up the newspaper. They are not looking for those advertisements, except they are actively looking for a job. But nowadays, with everything online, even when you didn't apply for a job, all you need to do is to register with all these online recruitment centers. Once a new advertisement is placed, they will start sending you email. Oh, job offer. Oh, new job posting. So it's going to be, even people who have jobs will tend to apply now, because especially if they see that the advertisement is going to pay them more than what they are currently getting. So yes, it is tough, but do they still get it approved? Yes, it can still be approved, but it is tough. And like I said, there are a few exceptions to it. Schedule A occupation, nurses and physical therapists, they don't need to go through this labor certification. uh Ministers, pastors, reverend, all those things, people in the religious employment, they don't need to go through this labor certification. And of course, sheep herders, which I said, since I've been practicing, I've never done one. I don't really understand what it even means to be a sheep herder. So I don't know. But those are some of the exceptions to this labor certification process. Is it approvable? Yes. Is it tough? Extremely tough. The next question: is it possible to get premium processing for palm application? No. Remember, this is not immigration process. This application is not an application with USCIS. This is not an application with the Department of Homeland Security. It is an application with the Department of Labor, so they don't offer premium processing. And of course, premium processing will defeat the whole purpose. The whole purpose of labor certification is for the employer to offer the position to American citizens. So that is not something they want to rush. If they rush it, there is tendency that Americans who actually need job may miss the opportunity. So they are not going to rush it. So there is no provision for expedited processing when it comes to permanent labor certification. The next question: what happens if US workers apply for the job during the recruitment? Then the employer will have to hire them. And if the employer chooses not to hire them, the employer cannot, in good faith, continue with the application for labor certification. Because when the employer is applying for labor certification, they are telling the Department of Labor that, look, we want to hire a foreigner because there are no American citizens interested or eligible for this position. So if there are Americans who apply, then there will be no basis to hire a foreigner. So the employer has to either hire them or forget about hiring a foreigner.
Provided that they qualify for the job, of course. If not, you will have to send them an email and tell them why you rejected them, right? Or why.
Yeah, if an American apply, yes, the American will have to be eligible for the position. Right. They cannot just hire them simply because they are Americans. They still have to be eligible for the position. And of course, where the employer decide not to hire them, they must provide a reason why the employer believe that they are not eligible. The next question: what is the typical timeline for the PAM process from start to finish. Well, this is I will say that from start to finish, probably about 6 months, assuming that the the recruitment steps were followed diligently. The employer should be able to complete the recruitment steps within 6 months. But of course, as to the timeline for approving the labor certification, that I cannot provide because there are so many complicated factors that affect the timeline. For example, before the employer can even start the recruitment process, except the employer is actually offering an irresistible salary. If it is an employer who want to offer an average salary, the employer will have to start with what is called prevailing wage determination. That process alone takes months. Application for prevailing wage determination to the Department of Labour can take up to 3 months, sometimes more than that. So that is already part of the process. So where the employer is waiting for the Department of Labour to offer them, to give them guidance on how much salary, what is the minimum salary, then the employer cannot even start the recruitment process until that prevailing wage determination is adjudicated. Because if, for example, the employer places advertisement that says that the salary is $100,000, if the Department of Labour comes back after to say that for you to hire this lawyer in Dallas, you need to pay the lawyer 150,000 or even 110,000, that means the advertisement is useless. Because if the employer went ahead to use that advertisement to apply for permanent labor certification, the application will be denied. Because the Department of Labour will say that the the offered salary is less than the prevailing wage. That will be a ground for denial. So to be on the safe side, for such an employer, it is better to submit an application for prevailing wage, wait for the determination before placing an advert. Because once a determination is made, that determination is valid for 6 months. So within the 6 months, the employer can quickly place an advert in the newspaper or online quoting the salary at least equal, an amount equal to or higher than the prevailing wage. But where the employer is willing to offer generous amount, then the employer does not need to wait. For example, if the employer knows that maybe an average lawyer in Dallas gets paid 100,000 and the employer decides to offer 150,000, the employer does not need to wait for prevailing wage, because definitely the prevailing wage is not going to come back with 150,000. It's probably going to come back with a less amount. So in such a situation, the employer does not need to wait. They can commence the process. But if the employer is on the average, you want to wait, because even if you miss the prevailing wage by $1, it will be a ground for denial. The next question: what happens if my PAM application is audited? I believe I already answered that. An audited application can attract sanctions, especially if the after audit, of course, after audit, if everything is okay, they can still go ahead and approve it. But after audit, if the Department of Labour determined that the employer was actually trying to reserve that position for a particular applicant, the employer could be given fine. The employer could be banned from ever hiring a foreigner. The employer could be temporarily suspended. It could be a lot of series of sanctions or series of punitive outcomes for the employer. Next question: what are my employer's responsibilities during the PAM process? Well, the entire PAM process belongs to the employer. There is nothing in the PAM process that involves the beneficiary. The only time the beneficiary's name will come up is when the employer is submitting an application for a permanent labor certification. because for the employer to submit an application for permanent labor certification, the employer is trying to confirm directly or indirectly that after the recruitment process, the employer was not able to find an American who is qualified. So the employer will now have to mention the name of the foreigner that the employer is looking at. So this is the only time that the applicant's name comes up. Of course, the employer will mention the name of the applicant, mention the credentials, the qualification of the applicant. Of course, in the application, the employer will have to indicate what the minimum requirement for the position is and the other requirement, and then the employer will also need to mention that this particular applicant meets this requirement. So that is the only time that the applicant name will come up. Other than that, every of this process from start to finish is the responsibility of the employer. The next question: may an employer set job requirements which are not customarily required for the occupation in the US? This is very rare. It is not a yes or no straight answer. Generally, a position must be something that is common to the industry. It must be a position, the requirement must be common to the industry. However, in extremely limited situation, an employer may be able to justify why the employer is going outside the industry. Let me give you an example. I remember a long time ago, I represented a religious organization that was filing H1B on behalf of somebody who studied computer science. Now, immigration issued a request for evidence, and they stated that, look, this is a religious organization. It is not common in the industry, in the religious world, for a religious organization to hire somebody who studied computer science. That is not common. That the employer should justify why they want somebody who studied computer science. Of course, we responded to the request for evidence at the time. Like I said, this was a long time ago. This is not in today's world. It would have been much easier to justify. But at that time, we had to go out of our way to explain that, look, the world is changing. Even though computer science is traditionally not associated with religious organization, but here is a religious organization that is trying to incorporate technology into its system. And the only effective way to do that is to hire somebody who understands the technology. They are trying to use computers to enhance many of their programs. And they need somebody who is an expert in computer science to be able to do that. So we have to make that explanation. But the point I'm making is that it is possible to deviate from the industry, but the employer will have to explain the specific need, why they are hiring someone who is not familiar or peculiar to the industry. The next question: I heard that it is possible for the Department of Labor to audit an employer. What triggers an audit? Well, I think I've answered that question before, but I will just summarize it. So many factors can trigger an audit. For example, if one of the places where an employer is required to place advertisement for the purpose of recruitment step is the state workforce agency. Now, state workforce agency, that is where American citizens go to apply for unemployment. It is possible that maybe unemployment is rising in the country. You know that in this country, I don't know if it is monthly or by, I know that they always release employment record, the statistics. Is it monthly? Is it a monthly thing or quarterly thing? I know that politicians always use it to whenever they release that, oh, unemployment, the figure has come down to 6%, 2%, and all of. So if, for example, unemployment is rising, and here is an employer claiming that there are no Americans willing to do the job, that can trigger an audit to be sure that how can this be consistent? How can high unemployment and employer not finding an interested candidate, those two things cannot go hand in hand? That can trigger an audit. Secondly, again, because the employer is required to place advertisement with the state workforce agency, that is where American citizens go to apply for unemployment. It is possible that during this recruitment stage, maybe an American has applied for unemployment. One of the conditions for unemployment in the US is that the applicant must be actively looking for job. So if an applicant, if a US citizen apply for unemployment, and then maybe they told the applicant that, oh, you are a lawyer, the law office of Olu Asekun is hiring, here is the advertisement, go there and apply. And then maybe this person applied following the instruction. Remember, the law office is not going to know that this person was referred by the Department of Labor. So we are not going to know. Maybe this person just submitted an application, maybe the application was reviewed, maybe we invited this person for interview and then get back to you. Maybe few months down the lane, maybe the person continue to apply for unemployment, and then the Department of Labor is wondering, oh, you are a lawyer, 3 months ago we told you that the law office of Olu Asekun is hiring, how come you didn't apply? Well, we are going to deny your application for unemployment because you are supposed to be actively looking for job, and where we specifically directed you to a place where you can get a job and you didn't do it, then that would be a ground to deny your application for unemployment. Then maybe this person responded, oh, I applied to that place, they invited me for interview and they told me they will get back to me, and they never did. Of course, if the Department of Labor is already armed with that kind of information, and then the law office went ahead after that to submit an application for labor certification claiming that there are no US citizens interested or eligible, that is going to trigger an audit right there, because the Department of Labor will be wondering, oh, you told us you applied, this person applied, and the employer is telling us that there are no applications. Okay, can you tell us, can you send us copies of all the applications that you received? That can trigger an audit. And of course, the content of an advertisement is also another thing that can trigger an audit. There's a very thin line between what is legal and what is not. So if the content of the advertisement includes something that is illegal, like the example that I gave before, maybe you want the applicant to be able to speak a specific language, that is illegal. That application could be summarily denied. There may not even be need for any audit. However, if the advertisement is such that the specific requirement seems targeted at a particular individual, but there is something illegal about it, if it is not illegal, they cannot summarily deny it. But the Department of Labor can choose to audit the employer to see that this was actually a good faith effort at recruiting, not something just to meet the minimum requirement. So that again, there are so many factors that can trigger an audit, and those are some of them. The next question. How can I maintain my legal status while PAM process is pending? Well, this has nothing to do with the Department of Labor. Anyone who is not a U.S. citizen or a permanent resident must be maintaining legal status at all times while an application for labor certification is pending. So it depends on what status you were previously. As I explained before, if you were previously on H-1B status, although H-1B requires that it can be granted for a maximum of 6 years, but if an application for labor certification has been pending for more than 6 years, and for more than 1 year, that can be a basis to continue to extend the H-1B beyond the 6-year period. But even where the applicant is unable to extend the H-1B beyond 6 years, or if the applicant is not even on H-1B, the applicant must be able to find other means to maintain legal status, maybe by going back to school or getting on F1 or any other non-immigrant status. The applicant just cannot afford to be out of status, because every single employment-based immigrant petition requires an applicant to be maintaining legal status in order to be eligible for adjustment of status. The next question: can we appeal a denial? Yes. Yes, if an application for labor certification is denied, if the employer believes that the allegation or the reason profiled by the Department of Labor is, if the employer disagrees with the reason, yes, the employer can file an appeal. There is provision for appeal. It can be appealed. The next question: what is the name of the department in charge of processing PAM? Oh, I've answered that million times. It is the Department of Labor. The next question: can the labor certification process be avoided entirely? Oh yes, if you are in a Schedule A occupation, or Schedule A occupation include nursing, physical therapy, and of course religious employment, as well as sheep herders. If you are in any of those professions, yes, you can avoid permanent labor certification. And of course, if you are applying through EB1, yes, you can also avoid it. Or if you are applying for EB2 in the national interest, you can also avoid it. If you are applying for EB4, special immigrant, you can avoid it. And if you are applying for EB5 as an investor, employment creators, yes, you can avoid it. Other than that, there is no way around it. Looking at the time, I believe we are after 1 o'clock right now. Do I have any other question? That seems to be my last question. Okay. In the absence of any more questions, we'll be hanging up today. We hope that you will join us next week again for another edition of our program. Remember, it is important that you continue to encourage us by inviting your family, friends, co-workers, and all of that. That is the only thing that you can do to show appreciation for all this information we are providing free of charge. Remember that we are not charging for this. We are doing this just to ensure that we prevent avoidable mistakes or avoidable errors. The Bible says that our people perish for lack of knowledge. Knowledge is key, and knowledge and information can serve as a difference between somebody whose immigration process or path is smooth versus somebody who embarked on Israelite journey. That is what we are trying to prevent. We have had situations of people who entered the United States and became a U.S. citizen within 2 years of entry. We have seen situations where somebody entered the United States even with a visiting visa and became a U.S. citizen within 3 years of entry. We have also seen situations where people have been in this country for more than 20 years, even though they entered legally, but they still don't have legal status. What makes the difference? Information. That is the information we are providing. And the only way you can show appreciation is just to let other people. What benefit will it serve you if you are getting all this free information and you are not sharing it with others? You never know. You may even be a US citizen thinking that this thing is, you are not concerned with this information. That may be a mistake. You may not be concerned truly, but you may have a family member who can benefit from this information. Even your own situation may change. You may have a family member you want to petition for. You may have a friend who is going through immigration status. You don't want to misadvise them. You can always refer them to this podcast. So that is why you never know where this information can be useful. Therefore, continue to encourage us so that we'll keep going. It is not easy to keep coming every week, and we have been doing this for years now. We are not doing it for any financial gain. For those who don't know, if you are doubting it, go to our website. Try to schedule an appointment with me. This is not about boasting or anything. You will see that you may not even get appointment with me until October. So what I'm saying in essence is that I'm very, very busy. And out of my busy schedule, I'm doing this every week. Not because I want clients, not because I need money. It is just my desire to help as many people as possible. The only way to show appreciation is to also let other people benefit from it. I hope to see you again next week. If you also have a topic that you believe we should discuss, send a text message to us or send an email or even send it through this platform. We will address it. To the best of my knowledge, there is no immigration topic that we have not discussed on this platform. But I may be wrong. If there is a topic that you are interested in and you think we have not addressed, bring it up and we will address it. Thank you again. Hope to see you next week.